Good day, everyone. So we are already at subsection 2 of chapter 4, which is the warranty against hidden defects of or encumbrances upon the thing sold. To start off, let me read first Article 1561. The vendor shall be responsible for warranty against the hidden defects which the thing sold may have, should they render it unfit for the use for which it is intended, or should they diminish its fitness for such use to such an extent that, had the vendee been aware thereof, he would not have acquired it or would have given a lower price for it. But said vendor shall not be answerable for patent defects, or those which may be visible, or for those which are not visible, if the vendee is an expert, who by reason of his trade or profession should have known them. Article 1561 focuses on the requisites of warranty against hidden defects. But before that, let me define some terms first. Redivision. This is the avoidance of a sale on account, which renders its use impossible or so inconvenient of some device or defect in the thing sold, which and imperfect that it must be supposed that the buyer would not have purchased it had he known of the vice. Simply speaking, redivision is an action to avoid the selling of a defective thing sold by the seller, because it cannot perform for the purpose it was purchased. Second term, redivision action. This is an action instituted to avoid a sale on account or some vice or defect in the thing sold, which render its use impossible, or so inconvenient and imperfect that it must be supposed that the buyer would not have purchased it had he known of the vice. In here, redivision action is an action to cancel a sale in consequence of defects in the thing sold. Last term to define is redivision vice or defect. This is a defect in the article sold against which defect the seller is bound to warrant. The vice or defect must constitute an imperfection, a defect in its nature of certain importance, and a minor defect which does not give rise to redivision. Redivision vice or defect is a flaw in the thing sold. A defect is a default which is so severe that it diminishes the use or the value of the object being sold. Additional information is that a mere absence of certain qualities known to the buyer does not necessarily mean that a thing positively suffers from redivision. Next, clarify ko lang that a defect which is hidden or latent. A defect is hidden or latent if it was not known and could not have been known to the vendee. It is one which is hidden to the eyes and cannot be discovered by ordinarily careful inspection or examination. Obviously, there is no warranty against hidden defects if the defect is not hidden or the patent is visible. So let's go to the requisites for warranty against hidden defects. We have 6 requisites provided in this article. The first one is the defect must be important or serious. Second one, it must be hidden. Third, it must exist at the time of the sale. Fourth, the vendee must give notice of the defect to the vendor within a reasonable time. Fifth, the action for rescission or reduction of the price must be brought within the statute of limitations. And last requisite is that there must be no waiver of warranty on the part of the vendee. These requisites will be thoroughly discussed on the next articles, but let's have a quick discussions of this para lang may background tayo, okay? So, when the defect made the thing unfit for the use for which it was intended, the use must have been stated in the contract itself, or can be inferred from the nature of the object, or from the trade or occupation of the buyer. So, simply speaking, yung purpose ng thing na subject sa contract must be stipulated by the parties, or in the absence naman ng stipulation, is adapted to the nature of the thing and to the business ng purchaser. So, yung tatandaan lang natin dito is that the defect has to be of such a severity that it would make the thing unfit to serve its purpose. So, for example, A and B entered into a contract of sale, whereby the object of the sale is a residential building. Here are some examples of defects which are deemed to make a residential building unfit to live in. First one, kung yung immovable is affected na ng mold, which is a health hazard, right? And then next one, the water is unfit for consumption. Kasi yung building pala was built a long time ago na. So, yung water is contaminated na. So, dito naman tayo sa when is a defect considered serious and important. Ito yung first requisite na nabanggit ko kanina, and in here may two requirement tayo for a defect to be considered serious and important. The first one is if it renders the thing sold unfit for the use for which it is intended. Second one, if it diminishes its fitness for such use to such an extent that the vendee would not have acquired it had he been aware thereof or would have been given a lower price for it. Sinasabi lang dito na if that thing na may defect won't serve its purpose anymore dahil nga may sira na, and kung alam lang ni buyer na ganun na pala yung condition ng thing, sana binili niya na lang sa mas mababang presyo, then considered serious and important yung defect. And then next one, when is a defect considered hidden? A defect is hidden if it's not known or could not have been known to the vendee. It is one which is hidden to the eyes and cannot be discovered by careful inspection or examination. Nabanggit ko na to kanina. As I've said, the defect is hidden or latent if it was not known and could not have been known to the vendee. So, even if may defect yung thing, kailan natin masasabi na hindi liable si seller? So, here are the instances where vendor is not liable. First, patent defects are those which may be visible. There is no warranty if the defect is visible, right? The vendor's liability for warranty cannot be enforced although the defect is hidden if the vendee is an expert who should have known it. So, papasok naman to sa second requisite. Those which are not visible if the vendee is an expert who by reason of his trade or profession should have known them. Take note that if the defect is hidden, but si buyer is an expert who by reason of trade or profession should have known that the defect, kahit na nakatago man to or kahit na nakikita niya, then warranty against hidden defect is not applicable and seller is not liable. So, yung pinaka-rational lang dito is, pag may expertise yung buyer and may defect yung binili niya, hindi liable si seller, and the reason behind that is because he is an expert. So, he should have known it. He should not have known kung yung thing na binibili niya is defective or not, either hidden man or visible, because it is expertise to begin with. Next, when is warranty against hidden defect applicable? In order for warranty against hidden defect to be applicable, the absence or the presence of the latent defect must be assessed and exist at the time of the sale. Tatandaan natin yon, at the time of the sale. This wording requires that one must be able to establish the moment at which the sale was made in order to determine, at a future date, whether or not there existed a latent defect on the property and or its accessories at the specific time of sale. The defect must be latent and unknown to the buyer at the time of the sale. The seller will not be required to guarantee the property against a defect that started after the sale. So, yun nga, sinabi ko kanina, the defect should exist at the time of the sale, not after. Please take note of that. Nor to provide a guarantee for the defect which was known by the buyer at the time of the sale. Next, where defect patent or made known. A warranty in general terms does not cover defects which the buyer must have observed. So, kung visible yung defect nakita ni buyer, obviously hindi siya covered ng warranty kasi nga hidden defects tayo. Second, the rule is applicable applicable to a defect which is not obvious, but of which the seller tells the buyer, or which the buyer knows or should have known. A well-recognized limitation on any doctrine freeing the seller from liability for statements or promises in regard to obvious defect is that if the seller successfully uses art to conceal the defect, the seller is liable. So, take note dito, if the seller successfully uses art to conceal the defect, the seller is liable. Ang rule dito, the rule is applicable to a defect which is not obvious, but seller tells buyer. So this is made known to the buyer, or buyer have known the defect by reason of expertise. Lastly, for this article, sa remedy naman. It must be stressed, however, that the remedy against violation of warranty against hidden defect is either to withdraw from the contract, which is action rehibitoria, or to demand a proportionate reduction of the price, ito yung action quanti minoris, with damages in either case. So in here, like sa mga previous articles na na-discuss specifically about sa loss of the thing at the time of perfection, same lang din yung remedy, which is to withdraw or continue with the contract, but only paying the proportionate price. So example in here is that A and B entered into a contract of sale whereby the object is a car, specifically a red Mustang with the plate number of A123. But the problem is unknown to the buyer. May hidden defect pala yung car. Let's say sa engine, which is hindi naman makikita kasi nasa loob yun. The remedies of B as the buyer is that he can withdraw from the contract or pay the price but less the cost of damages. So kung let's say 1 million yung car and the defect costs around 100,000, then B will only have to pay 900,000 na lang. So that ends Article 1561. Let's proceed to Article 1562. So Article 1562 talks about in a sale of goods, there is an implied warranty or condition as to the quality or fitness of the goods as follows. First, where the buyer, expressly or by implication, makes known to the seller the particular purpose for which the goods are acquired, and it appears that the buyer relies on the seller's skill or judgment, whether he be the grower or manufacturer or not, there is an implied warranty that the goods shall be reasonably fit for such purpose. Second, where the goods are brought by description from a seller who deals in goods of that description, whether he be the grower or manufacturer or not, there is an implied warranty that the goods shall be of merchantable quality. So let's discuss first what is an implied warranties of quality. Quality of goods includes their state or condition. The purpose of holding the seller on his implied warranties is to promote high standard in business and to discourage sharp dealings. They are based on the principle that honesty is the best policy. Kailangan merong warranty sa quality since it will promote higher business standards and discourage dishonest dealings ng mga sellers. Dito ma-apply yung honesty is the best policy principle. We want sellers to be honest to us, the consumers. Implied warranty is an assurance that a product is fit for its intended purpose and meets the buyer's expectations. Siyempre, as a buyer naman, everyone can relate to this. Sinisiguro muna natin yung quality ng mga binibili natin before actually purchasing it. It is a lot like an assumption. For example, when you bought a Caesar salad sa isang restaurant, the implied warranty in there is that the salad is edible. Or when you bought a car, the implied warranty in there is that it perfectly works because it's new. Moving on to warranty of fitness or implied warranty of fitness for a particular purpose. So ano nga ba ang warranty of fitness? This is a warranty imposed by law if the seller has a reason to know of the buyer's special purpose or the item, and that if the item is suitable for those purposes. The general rule in here is that there is no implied warranty as to the quality of fitness for any particular purpose of goods under a contract of sale, except as follows. A. The buyer, expressly or by implication, manifests to the seller the particular purpose for which the goods are required. For example, sinabi ni buyer na I'll use this para sa ganitong purpose. Then, tinanong si seller if he can use it for that particular purpose na gusto niya. And if the buyer relies on that representation or the seller that the thing is fit for that particular purpose where the buyer would want to use the thing, then there is already a warranty of fitness. Next, letter B, the buyer relies upon the seller's skills or judgment. Then, whether he be the grower or manufacturer or not, there is an implied warranty that the goods are reasonably fit for such purpose. If the buyer justifiably relied upon the seller's judgment naman that the goods he bought would fit for the particular purpose that the buyer mentioned, then the buyer has the right to avail warranty of fitness. For example, if a farmer goes to a farm supply store and tells the salesman he needs a plow, yung panghukay, for the rocky soil of his farm, and the salesman directs him to a particular plow, there may be an implied warranty that the plow in question is fit for use in a rocky soil. Next, warranty of merchantability or implied warranty of merchantability. A merchant seller's warranty that is implied by law and that the thing sold is fit for its ordinary purposes. So, ano nga ba ang merchant? A merchant is a person who buys and sells goods, especially on a large scale or within foreign countries like wholesaler. In here, goods are bought by description, where the seller impliedly warrants that the goods are of merchantable quality. Merchantability is not a warranty of quality in the sense of requiring a particular grade, but it does require identity between what is described in the contract and what is tendered, in the sense that the latter is of such quality to have some value. Note that the merchantability is not a warranty of quality. It does not require a particular grade or quality, but it will require identity between what is required in the contract and what is given to the buyer. So, pag sinabing merchantability, yung goods are saleable, standard, or average quality. For example, in every sale between a merchant and a consumer, there exists an implied warranty of merchantability. This means that the goods bought will be fit for their ordinary use. So, if you buy a golf club from a golf shop, let's say, there is an implied warranty in there that the sale of the golf club will perform as it was designed to. Last topic for Article 1562. Let's distinguish warranty of merchantability from warranty of fitness. So, a warranty of merchantability is a warranty that goods are reasonably fit for the general purpose for which they are sold. On the other hand naman, a warranty of fitness is a warranty that the goods are suitable for the special purpose of the buyer, which will not be satisfied by mere fitness for general purposes. So, pag sinabing warranty of merchantability, goods are reasonably fit for the general purpose for which they are sold. While warranty of fitness, goods are suitable for the special purpose of the buyer. Maybe the special purpose of the buyer would not be satisfied by mere fitness for general purpose. So that's all for Article 51 to Article 1562. I hope you have learned something. Article 1563 to Article 1564 will be discussed by Ms. Janelle Martinez.
Article 1563. In the case of contract of sale of a specified article under its patent or other trade name, there is no warranty as to its fitness for any particular purpose unless there is a stipulation to the contrary. Klaro na dito sa article na to na kapag sinabing pag naka-obvious na or naka-indicate na sa kanyang patent or other trade name, there is no warranty as to its fitness for any particular purpose. For example, racing horse yung object dun sa contract. There is no warranty as to any particular purpose. Example, yung racing horse na yun is for good consumption of meat. Walang warranty as to that kasi specified na yung horse is for racing. Unless there's a stipulation to the contrary. For example, sa stipulation to the contrary, the buyer went to Auto Hub after he was shown different models and makes. He chose to get BMW M3 GT. Buyer intended to enter the car in a race, but this fact was not made known to the seller. If the car should not run as the buyer had expected, Auto Hub is not liable because in buying the M3 GT, he relied upon his own judgment. Doon na pumapasok yung rule number 1. Hindi magiging liable yung seller since yung buyer is nag-rely siya sa own judgment na. Papasok na dito yung limitation na stipulation to the contrary. But if the seller was informed of his purpose and buyer was assured that the car would run a maximum of 240 kilometers per hour, there's an express warranty for a particular purpose, and Auto Hub would be liable if the car should fit for such particular purpose. Doon na pumapasok yung second rule na kahit nagbigay siya ng brand, nag-rely pa rin siya dun sa sinasabi ng seller na kung mag-fit dun sa purpose na gusto niya, dun sa particular purpose na gusto niya. Yun lang yung sinasabi sa Article 1563. Article 1564. An implied warranty or condition as to the quality or fitness for a particular purpose may be annexed by the usage of trade. Dito, ang simple term lang dito is kahit hindi stated, it's still assumed to have implied warranty because all the facts and circumstances kung saan yung transaction nagaganap is present. Yung effect of usage of trade, yung ibig lang naman sabihin nito is kung ano yung nakasanayan na practice dun sa lugar na ginaganapan ng transaction. Means, meron na palaging implied warranty doon. For example, yung fair is para sa mga panabong na manok. Ang presumption doon is yung implied warranty doon, yung mabibili mong manok o yung mga manok na pwede mong mabili doon is for panabong na manok. Hindi pwedeng yung manok na yun is para paitlogin o kaya para pamparamihin. Yung mga binibenta na doon, yung typical, yung usual na binibenta doon sa fair na yon is mga panabong na manok. Yun na yung implied warranty doon. Article 1565. In the case of a contract of sale by sample, if the seller is a dealer in goods of that kind, there is an implied warranty that the goods shall be free from any defect, rendering them unmerchantable, which would not be apparent on reasonable examination of the sample. Yung general rule lang naman dito sa article na to is good, same as sample. Yung parang kung ano yung pinadala, kung ano yung pinakita sa yung sample, ganun mo siya marireceive in bulk or in mass, pang maramihan. Yung number 1 rule dito is where sample is not merchantable. Since yung general rule natin is kung ano yung pinadala sa yung goods, ibig sabihin kahit merchantable or unmerchantable yung sample na pinakita sa iyo, ganun mo siya marireceive. Kunyari, na-receive mo siya na unmerchantable mo na siya na-receive. Marireceive mo siya in bulk na unmerchantable na rin. Number 2 rule, second rule is when sample subject to hidden defect. Ito naman, yung implied warranty dito, since yung hidden defect na yun, hindi mo agad-agad, upon inspection, hindi mo makikita agad-agad. Dapat, reliable si seller dito na kung ano yung pinakita mo as it is, kung ano yung pinakita niya sa yung sample, ganun mo siya marireceive, which is parang wala naman siyang defect nung pinakita sa iyo, tas nung pinadala sa iyo meron na. Ang mga example ng mga product paminsan na merong hidden defects is leaking roof. Kunyari, pag bibili ka doon, syempre, ang tinitingnan mo doon is yung kulay, kung gaano kakapal yung bubong, kung gaano kahaba. Hindi mo siya makikita na may butas. Tapos, nung binili mo na in bulk, meron palang mga butas. Liable nun dun si seller na pwede niyang palitan yon. Gaya nung sinasabi dun sa Article 1481 na pwede mong i-cancel pag may nakita kang defect. Iyon yung mga parang hidden defect or mga latent defect na nakita mo dun sa sample. Ay, hindi mo nakita dun sa sample, pero nakita mo na nung in bulk. Pwede mong i-rescind nun yung contract na pinapasukan mo. For the next two Article 1566 and 1567, here's Miss Mary Rose Sanguyo.
Article 1566. The vendor is responsible to the vendee for any hidden faults or defects in the things sold, even though he was not aware thereof. In this article, sinasabi na si seller ay magiging responsible kay buyer kapag nagkaroon ng hidden faults or defects yung bagay na binenta niya kahit na hindi siya aware dito. And kahit na nag-act in good faith, si seller is still responsible pa rin siya sa liability. May doctrines tayo dito. Doctrines of caveat venditor and caveat emptor. When we said caveat venditor, let the seller beware. Dito, sinasabi na si vendor ay responsible kay vendee sa hidden faults or defects na binenta niya na things kahit na hindi siya aware dito. While caveat emptor, let the buyer beware. The rule of caveat emptor requires the purchaser to be aware of the supposed title of the vendor, and the one who buys without checking the vendor's title takes all the risks and losses consequent to such failure. Example, when si buyer 1, si buyer 2, and si seller. Si seller, binenta niya kay buyer 1 yung lupa. And si buyer 1, pinatitulo na niya and pina-register niya as an owner. Then, si seller, binenta niya ulit yung lupa kay buyer 2. Then, si buyer 2, kailangan siyang maging aware. Kailangan, i-check niya yung lupa sa Registry of Properties if may ari na ba sa lupa na yon, para hindi siya mag-takes ng risks and losses. Let's proceed to Article 1567. In the cases of Article 1561, 1562, 1564, 1565, and 1566, the vendee may elect between withdrawing from the contract and demand a proportionate reduction of the price with damages in either case. And in this article, sinasabi na si vendee o si buyer pwedeng pumili between mag-withdraw sa kontrata or mag-demand na lang ng proportionate reduction dahil sa damages na meron yung things na binenta. Meron tayong dalawa dito, action redhibitoria and action quanti minoris. Kapag sinabing action redhibitoria, dito, the remedy of buyer to withdraw or cancel the sale because the item sold has defects and it is not known by the buyer when he bought it. Or the buyer can return the item and get the money he paid to the seller. So, sinasabi dito na pwedeng mag-withdraw na lang yung sa kontrata, yung seller, yung buyer, at kunin na lang yung pera niya kay seller. Example is, kapag si Ana, bumili siya ng cellphone charger kay Mahler. Then, si Mahler, yung cellphone charger, tinry niya sa store niya and gumagana naman. While si Ana, binili na niya yon kasi alam niya na gumagana na. Then, kauwi sa bahay, si Ana, tinry niya yung cellphone charger sa cellphone niya. Pero, ang nangyari, imbis na tumataas yung battery niya, battery charge, mas lalong bumababa yung battery charge. So, si Ana, meron siyang karapatan na ibalik yung cellphone charger kay Mahler at kunin na lang yung pera na binayad niya. Next is action quanti minoris. Dito naman sa action quanti minoris, pwedeng si purchaser, pwede na lang niya i-claims yung reduction of price kapag merong defects or merong sira yung bagay na binili niya. Example neto, si Ana, nagbebenta siya ng cellphone. Yung cellphone, okay naman. Tapos, pagdating naman kay Malor, gusto niyang bilhin yung cellphone. Pero nakita ni Malor na yung cellphone ay parang may crack yung camera sa likod. Then, si Malor, dahil gustong-gusto niya yung cellphone, sinabi niya kay Ana na bawasan na lang yung price dahil nga may defects naman yung cellphone na binebenta niya. Nabawasan na lang yung price at bibilin niya yung cellphone na yon. That is example action quanti minoris. Okay, let's hear Article 1568 to Rosemary.
Article 1568. If the things sold should be lost in consequence of the hidden faults and the vendor was aware of them, he shall bear the loss and shall be obliged to return the price and refund the expenses of the contract with damages. If he was not aware of them, he shall only return the price and interest thereon and reimburse the expenses of the contract which the vendor might have paid. So there are two mentioned effects of loss of things sold on account of hidden defects. The first one is if the vendor was aware of the hidden defects, siya yung magbe-bear ng loss kasi he acted in bad faith. Because of that, yung right na vendor to recover is price paid and expenses of the contract with damages. While the second one is if the vendor was unaware sa hidden defect, he is obliged to return the price paid and interest thereon as well as the expenses of the contract kung si Bendy ang nagbayad. Moreover, since not guilty of bad faith si vendor dahil nga unaware siya, hindi siya liable for damages. So, for example, Plain sold to Dominic a car and the expenses of the contract was paid by Dominic. Si Klein, aware siya na nagloloko yung alarm system and locking system ng car pero hindi niya sinabi kay Dominic. After ilang days, ginamit ni Dominic yung car para bumili. Pinark niya sa kabilang daan, naiwan yung susi sa loob, pero he makes sure na nalock ng maayos yung car using the remote control for locking the car. Unfortunately, madaling nakarnap yung car dahil nga sa may sira sa locking system and alarm system kasama yung mga gadgets na naiwan sa loob ng car. Dominic then has the right to recover the price paid and expenses of the contract with damages. However, if unaware si Klein sa hidden defects sa locking system and sa alarm system, obliged pa rin siya i-return yung price paid and interest thereon, as well as yung expenses ng contract. Hindi mare-recover ni Dominic yung damages because Klein is not guilty of bad faith since he is unaware. Article 1569. If the thing sold had any hidden fault at the time of the sale and should be thereafter be lost by a fortuitous event or through the fault of the vendee, the latter may demand of the vendor the price which he paid, less the value which the thing had when it was lost. If the vendor acted in bad faith, he shall pay damages to the vendee. Naturally, if the thing sold had no hidden defect and the loss is through fortuitous event or fault ni vendee, susundan yung general rule ng res perit domino na the thing perishes with the owner. Pero kung may hidden defect, liable si vendor on his warranty wherein obliged siya to return the price paid, less the value of the thing at the time of loss. In simple words, ibabalik ni vendor yung price equivalent sa hidden defect. As what is stated sa last sentence ng article, if the vendor acted in bad faith, he shall pay damages to the vendee. So for example, Klein sold to Rafa a tricycle for 57,000 pesos. Rafa used it to drive pero bigla siyang nawalan ng control and nabangga sa poste. So kinabukasan, dinala ni Rafa sa repair shop ng tricycle and there he found out the hidden defects na nakita ng repairman while inspecting the tricycle. Nagbayad si Rafa ng 3,000 pesos for repair and necessary equipment ng hidden defect na yun. Because of that, Klein is obliged to pay 3,000 pesos which is yung equivalent ng price paid of 57,000 pesos less the value of the tricycle at the time of the loss na 54,000. So our next reporter is Ayara Pamintuan.
Article 1570. The preceding articles of this subsection shall be applicable to judicial sales, except that the judgment debtor shall not be liable for damages. So dito, yung mga previous articles applies to judicial sales also, or yung sales by the order of the court, but that judgment debtor, for example, meron siyang na-violate yung warranty against hidden defects, na-violate yung warranty against eviction. So, ang mga mag-a-apply yung mga rules. Pero the seller, the owner of the thing, or yung judgment debtor will not be liable for damages. Because here, sa pilitan kasi yung pagbibenta. Hindi naman talaga gusto. This is a sale against the will of the owner of the thing. So, that is Article 1570. So, the next one is Article 1571, prescribed period. The action for rescission of the contract or reduction of the purchase price. Action redivitoria or action quanti minoris, prescribed 6 months from delivery. So, what is action redivitoria? It is the action to withdraw from the contract. And then, the action quanti minoris, it is the reduction of the price with damages. So, anyway, if you notify the seller of the hidden defects, but you did not sue or file an action, the action, the right to file an action, will of course prescribe. That is just the meaning of Article 1571. Just simple as that. So let's move on to Article 1572. If two or more animals are sold together, whether for a lump sum or for a separate price for each of them, the redivitory defect of one shall only give rise to its redivision, and not that of the others, unless it should appear that the vendee would not have purchased the sound animal or animals without the defective one. The latter case shall be presumed when a team, yoke, pair, or set is bought, even if a separate price has been fixed for each one of the animals composing the same. So, the general rule here is when two or more animals have been sold at the same time, and the redivitory defect is in one, or some of them but not in all. The general rule is that the redivision will not affect the others without it. It is immaterial whether the price has been fixed for a lump sum, for all the animals, or for a separate price for each. So remember here, the general rule is that yung defect of one will not affect yung others which are not defective. Mayroong exception, and the exception is when it can be shown by the vendee that he would not have purchased the sound ones without those which are defective. Such intention need to be established by the vendee but shall be presumed when a team, yoke, pair, or set is bought unless the vendor proves the contrary. So, the vendee would not have purchased yung walang defect kung hindi kasama yung may defect. For example, yung mga lovebirds. Usually, yung mga lovebirds, di ba, binibilian by pair. So, bibili ka ng isang lalaki and isang babae para magkaroon sila ng mga anak, di ba? Tapos, yung babaeng ibon, bawg pala. Hindi mo bibilhin yung lalaking bird kung alam mo lang na yung kasamahan niyang babaeng ibon is bawg pala. So, if it can be shown that the buyer would not have yung lalaking bird, kung hindi kasama yung babaeng lovebird, which turns out to be defective. Remember, there is an exception. So, yung redivitory defect of one will affect yung others which are not defective. So, take note here in 1572, it provides that a redivitory action or action redivitoria can be filed but even if not provided. Take note also that an action quanti minoris may be filed instead of yung action redivitoria. So that is the Article 1572. For Article 1570, 1571, and 1572. The next articles, which would be Article 1573, 1574, and 1575, will be covered by Ms. Marian Joy Bayani.
Article 1573. The provisions of the preceding article with respect to the sale of animals shall in like manner be applicable to the sale of other things. So, yung previous article natin na Article 1572 is applicable din siya dito sa Article 1573 na which talks about the sale of two or more things together. So, yung general rule nila is the redhibitory defect of one thing will only give rise to its redhibition and not of the other thing. So, yung example ko dito is inutusan akong bumili ng pair of or set of tires. Itong tires na mga to, gagamitin siya pang reserve lang or pang extra lang if sakali man na masiraan ng gulong yung sinasakyan namin. So, pumunta ako sa isang shop, nagbabenta sila ng set of tires, and upon checking the things, may nakita akong isa na defective. So, dito mag-a-apply yung general rule na hindi madadamay yung buong set ng thing kahit na may isang defective. So, merong exemption na unless it is shown that the vendor or the buyer will not buy the whole thing or yung set kung wala yung defective one. So, yung example ko dito is along our road trip, nasiraan ng gulong yung sinasakyan namin. So, kailangan na namin siya talagang palitan. Nag-stop by kami sa isang shop. Bibili na kami ng set of tires kaso may nakita kami isang defective. So, dito, as a buyer, we are entitled to rescind the whole sale. Next is Article 1574. There is no warranty against hidden defect of animals sold at fairs or at public auctions or of livestock sold as condemned. So, dito sa article na to, we have assumptions na dapat nasabi na ng seller yung condition and information about sa animals kay buyer. So, dapat dito clear na and nasabi na din yung intention ni seller kung bakit niya binebenta yung hayop. So, dun sa fairs or public auctions, alam naman natin na live and face-to-face selling ito. So, talagang dapat yung information about the animals talagang nasabi na siya sa buyer. So, yung na-search ko dito kasi hindi rin ako aware sa mga ganito. So, nag-search ako na usually ginagawa ito sa mga farms na nalulugi na. So, dun naman sa of livestock sold as condemned, yung dito is usually yung mga hayop na to is kinakatay na lang or for food na lang talaga sila. So, yung example ko dito is meron akong alagang baboy. So, yung alaga ko na yon is 3 years na siya nasa akin pero hindi pa siya naglabas ng mga piglets or ng mga anak niya. So, luging-lugi na ako and di ko na kayang suportahan yung pangkain niya araw-araw. So, lumapit ako sa best friend ko, gusto mo bang bilhin yung baboy ko? Tapos sabi ni Angela, ala, bakit mo binebenta? Ngayon, as a seller, I have may responsibility ako na sabihin ko kay Angela yung dahilan. So, yung dahilan ko dito is hindi niya naman kaya mag-produce ng anak, so ibebenta ko na lang siya. Tapos, pwede kong sabihin kay Angela na pwede niya namang katayin yung baboy or bahala na siya kung ipagbebenta niya ba ito. So, dito sa article na to, yung mga hayop na binebenta dito is not for use of work or service. Yung mga hayop na to is ginagamit or binebenta and binibili for other reason. Next is Article 1575. So, the sale of animals suffering from contagious diseases shall be void. So, ito talagang pinagbabawal to kasi baka kumalat pa yung sakit sa ibang hayop, or worse is baka magkaroon pa ng sakit yung mga tao. So yung usual example na nangyayari talaga sa bansa natin is yung ASF and yung bird flu. So talagang nakikita natin sa mga balita na kumikilos yung DFA para masupo or yung ma-stop yung ganitong mga situation. Kapag may nakita silang nagbebenta ng mga hayop na may sakit, kamukha ng or katulad ng baboy at mga manok, kapag nalaman nilang may sakit yung mga binebenta nila, talagang pinapasarado and kinukuha yung mga binebenta nila. Continuation. A contract of sale of animals shall also be void if the use or service for which they are acquired has been stated in the contract and they are found to be unfit therefore. So, example, gusto kong mag-compete or sumali sa isang contest na horse racing. Kailangan ko ng kabayo. So, naghanap ako ng seller and upon reading the contract, biglang naging void yung contract namin. Ayun, kasi yung binebenta ni seller ng kabayo is pang tourist lang pala, yung mga ginagamit lang sa mga tourist spots. Yung gusto ko is yung kabayo na pang race. So talagang magiging void siya kasi unfit yung kabayo sa trabaho niya. So for the next articles, here is Lawrence Lugto to discuss it.
So let us proceed with Article 1576, wherein this article stipulates that if the hidden defect of animals, even in case of a professional inspection has been made, should be of such a nature that expert knowledge is not sufficient to discover it, the defect shall be considered as redhibitory. But if the veterinarian, through ignorance or bad faith, should fail to discover or disclose it, he shall be liable for damages. So first, let's go over a terminology used in this law, which is the word redhibitory. Redhibitory means a defect that renders a thing useless or so diminishes its usefulness or value. This law is applicable to the sale of animals. There are requisites to be considered redhibitory. The first one being, the defect must not only be hidden, but it must be of such a nature that expert knowledge is not sufficient to discover it. But if in any case the veterinarian failed to discover it through his ignorance or failed to disclose it to the vendee through bad faith, he shall be liable for damages. The responsibility is his and not the vendor's. So if we put it in a situation, if Mr. X purchased an exotic parrot from Mr. Y without knowing that the bird has been in fact infected by a strain of avian flu, and Mr. Y also not being knowledgeable of such, then the aforementioned situation, this can be considered as redhibitory like what was mentioned in the third requisite. If it so happens that the expert, which so happens to be a veterinarian in this situation, neglected his duties and did not disclose such matters in bad faith, then he shall be the one liable. Going through the next law, Article 1577, which states that redhibitory action based on the faults or defects of animals must be brought within 40 days from the date of their delivery to the vendee. This action can be exercised with respect to faults and defects which are determined by law or by local customs. So this law basically sets a guideline on what could be done in case a situation like the one mentioned on Article 1576 may arise. Limitation of action in sale of animals. The redhibitory action based on the faults of animals should be barred unless brought within 40 days from the date of their delivery to the vendee. This only means that if fault of animals should occur, action must be taken within 40 days and this time frame starts from the date of the delivery. According to the second paragraph, what should be considered redhibitory defects in the sale of animals are only those determined by law or by local customs. If the defects are patent, there is no warranty against such defects, although there exists a redhibitory vice, which is a seller that knows of a redhibitory defect but omits to declare it. or that declares the thing to have a quality he or she knows it does not. To sum it up, this article tells us what can and can't be done when redhibitory action is required and until when action can be considered valid based on the law or local custom. For our preceding article, Article 1578, we have Mr. Edwin Katakutan.
So let's continue the discussion. Article 1578, sabi dito, if an animal should die within 3 days after its purchase, the vendor shall be liable if the disease which caused the death existed at the time of the contract. So we have requisites kung kailan magiging liable si vendor kapag namatay yung animal. The vendor is liable if the animal should die within 3 days after its purchase. Note, after its purchase, not the date of the delivery, but the date of the sale. Second, the disease which caused the death existed at the time of the contract. Kailangan, nung contract pa lang, may sakit na yung animal. And third, the claim of the vendee must be based on a finding of an expert that the disease causing the death existed at the time of the contract. So, dapat may basis tayo dun sa finding ng expert para may proof na yung sanhi ng pagkamatay ng animal is existed na at the time of the contract. And if the loss is caused by a fortuitous event or by the fault of the vendee and the animal has vice, Article 1569 should be applied. So example for this article, bumili ng husky si A kay S. Kahit may lagnat yung aso, binili pa rin ni A kay S yung aso kasi nagagandaan siya and naniniwala si A nagagaling yung aso kasi simpleng lagnat lang yan. However, after 2 days ng pagkabili ni A, namatay yung aso kasi di na siya kumakain and matamay na siya. So yung cost ng pagkamatay ng aso is yung lagnat nga. So here, S is now liable to A kasi namatay yung aso within 3 days after its purchase. And yung sanhi ng pagkamatay ng aso is yung lagnat, which existed at the time of the contract. So, ganun lang kasimple yung Article 1578. Next article, Article 1579. If the sale shall be rescinded, the animal shall be returned in the condition in which it was sold and delivered. The vendee being answerable for any injury due to his negligence and not arising from any redhibitory defect or fault. So Article 1579 talks about the liability of the buyer in case the animal shall be rescinded. So first, the vendee may avail himself of the remedies granted by Article 1567. So na-discuss naman na yan. And next, the vendee must return the animal in the condition in which it was sold and delivered. So kung papaano natanggap ni vendee yung animal, dapat ganun niya pa rin ibabalik yan kay vendor. The vendee shall be responsible in case of injury due to his negligence. But this would be no obstacle to the rescission of the contract due to the redhibitory defect or the fault of the animal. And under Article 1556, the buyer may not ask for rescissions where he has created new encumbrances upon the thing sold. So, example for this article would be si A bumili ng sheep o tupa kay X. Sabihin na natin may defect yung binili ni A kaya gusto niya itong ibalik and he wants the contract of sale rescinded. Ngayon, kung ibabalik ni A ito kay X, dapat ibabalik niya ito kung paanong condition niya natanggap yung tupa. For example, nung dineliver kay A yung tupa, nandun pa yung fleece o yung wool ng tupa. Dapat, kung ibabalik ni A kay X yung tupa, dapat nandoon pa rin yung fleece or yung wool. However, another scenario, nung isasakay na yung tupa dun sa truck para ibalik yung animal kay X, nasugat ito or napilay due to the negligence of A. So here, A is responsible for the treatment of the injury of the sheep or the tupa kasi fault niya yun. Pero hindi ito magiging sagabal dun sa rescission ng contract. Kasi in the first place, may defect yung tupa, kaya niya ito binabalik. Kahit napilay pa to, kahit na sugatan pa to, pwede niya pa rin ibalik given that ipapagamot ni Vendi yung animal kasi nga fault niya yun. And for the next two articles, which would be Article 1580 and 1581 would be discussed by Ms. Angela Borsal. Thank you.
For the last two articles, Article 1580 and 1581. So Article 1580, in the sale of animals with hereditary defects, the vendor shall also enjoy the right mentioned in Article 1567, but he must make use thereof within the same period which has been fixed for the exercise of the hereditary action. So this article talks about the alternative remedies of the vendee or the buyer in sale of animals with hereditary defects. I think you already have an idea of what a hereditary defect is since it was already mentioned in previous articles. So just like what have mentioned in 1567, the buyer shall also enjoy a right in case the sale of animals with hereditary defects, either action hereditaria, it means the buyer can withdraw from the contract with the right to damages, or action quanti minoris. This means the buyer can demand proportionate reduction of the price caused by defects with still a right to damages. So, the vendor must present proof that he suffered damages as a result of the breach of the vendor's warranty to be entitled to acto. Also, do not forget that the action must be brought within 40 days from the date of the delivery of the animals to the vendee. So like for example, Mr. Andrew bought two horses from Mr. Sandro, one of which was discovered to have hereditary defect few days after the sale. So Mr. Andrew can only ask for the sale of the horse with defect to be rescinded or proportionate price reduction. He must take an action within 40 days because otherwise he will not be able to exercise the two rights mentioned. In Article 1581, the form of sale of large cattle shall be governed by special laws. Large cattle, it includes the cow, carabao, horse, mule, or other domesticated member of the bovine family. So in case of sale of large cattle, special laws govern the form of such sale. There shall be no person, partnership, association, corporation, or entity shall engage in the business of buy and sell of large cattle without first securing a permit for the said purpose from the provincial commander of the province where it shall conduct business, in the city municipal treasurer of the place of the residence of such person, partnership, association, corporation, or entity. The permit shall only be valid in such province. The sale must appear in a public document. Kaya may ganitong klaseng provision is to avoid cattle rustling. It is taking away by any means, method, scheme without the consent of the owner. So pag hindi nila pinakita yung permit or document na sila nga nagmamay-ari, may possession, control, or custody ng large cattle na yon, it shall be a prima facie evidence that the large cattle in his possession, control, or custody are the fruits of the crime of cattle rustling. And that is the end of the Group 3 presentation in subsection 2, warranty against hidden defects of or encumbrances upon the thing sold. Thank you for listening.